Hi, and welcome to this Fireside chat on the Family Law Amendment Bill 2023 exposure draft. This is Jackie Campbell sitting next to me. Jackie is an accredited family law specialist and a partner at Forte Family Lawyers in Melbourne. She's also a consultant editor and a contributing author for CCH's family law materials, all of which is to say that Jackie is an expert in the things that we're about to discuss.
And I'm here with Johannes Schmidt. And I jumped at the chance to present with Johannes because we've presented before. And Johannes was first off the blocks, I think, in publishing something about the new parenting bill. Johannes is a barrister and mediator, and he's on Foley's list at the Victorian Bar. We're going to talk about the draft bill, which was released on the 30th of January 2023. Submissions closed on 27th of February 2023. But I think we can expect that there'll be some draft legislation or further draft of the legislation later this year, following the consultation process. But we don't have a date yet for the release of that final bill. The exposure draft follows on from the Australian Law Reform Commission report and the Joint Select Committee. Some major changes are proposed to the parenting legislation. So firstly, Johannes, one of the changes is amendments to Section 60B of the Family Law Act in Part 7 of the Family Law Act. What are those changes?
Well, let's look first at what it currently has. So currently Section 60B has 4 objects and then 5 principles underlying them. Those objects are relationships with both parents to the maximum extent that's consistent with a child's best interests, protecting children from harm, ensuring that children receive adequate and proper parenting, and ensuring that parents fulfill their duties and meet their responsibilities. And then the underlying principles are that a child has the right to know and be cared for by both of their parents, the right to spend regular time and have regular communication with parents and other significant adults, that parents jointly share duties and responsibilities, that parents should agree on future parenting arrangements, and that children have a right to enjoy their culture. The bill would repeal all of that and replace it with 2 very broad objects, which are to ensure that the children's best interests are met and to give effect to the United Nations Convention on the Rights of the Child.
So, Johannes, what role do objects play when courts are determining cases?
It's an interesting question. Certainly, I cannot recall the last time I actually addressed a judge on the objects of Part 7. The only thing I can think of is perhaps if I was running an argument where I didn't have the best evidence to support my case, and couldn't tag certain things to a particular section and then revert it back to the underlying objects.
So when you're grasping at straws, Johannes?
Perhaps.
I'm interested in the fact that the UN Convention on the Rights of the Child has got such prominence in the objects. I mean, it is in the current. I want to keep saying it was the past legislation, but it is in the current legislation. But it's further down. It's sort of an additional object or an also, I think. But now it's got much more prominence because there's only 2 objects and it's one of them. So do you think there's going to be an extra role for the UN Convention that wasn't in the old Act or the current Act?
I don't know. I've got no idea, to be honest. I suspect it will still be those underlying best interests principles that will play the biggest part. But again, the question is, what role do the objects really play in practice other than being, I suppose, a bit of a mission statement for what the part is aiming to achieve?
I mean, it's interesting, I think, that the UN Convention does seem to have a bigger role because the aim of the legislation seems to be to simplify the legislation for the benefit of parties. But not everyone will have ready access to the UN Convention or know where to look to find it. So that will be interesting, I think, to see whether it does actually change things.
Yeah.
I'm also interested in the fact that whether or not we could expect different outcomes because there's the removal of the express reference to the benefit of both childs having a meaningful relationship in the lives of the children to the maximum extent possible has been removed. Is that going to change things, do you think?
Well, again, to me, it comes down to being a question of what role in practice do the objects play. I suspect that if we've got this generic ensuring that the child's best interests are met, that object can really only be, you can only work out what that means with reference to Section 60cc, which of course we're going to talk about in some detail shortly, because there are some significant amendments there. I suppose is what you're asking, whether removing that will demote those considerations?
I wonder that. Is that the intention of the government, to lessen the importance of a meaningful relationship?
I don't know. Sorry, I'm just waiting to get my iPad open again. What I was looking for is the press release released by the Attorney General on the 30th of January, when this draft exposure bill was released. And the aim seems to be to make everything more accessible, and to simplify the language. And that's sort of overall how I've read most of the bill, in terms of, to me, a lot of it seems to be keeping the effect more or less the same as the existing provisions, but using fewer words and making it simpler to understand. But whether that has unintended consequences, of course, remains to be seen.
Well, the Australian Law Reform Commission recommended replacing Section B, which sets out the objects and principles of Part 7, partly because it has inconsistencies with Section 60C, arguably. So I guess it does remain to be seen whether or not parties or their legal practitioners will latch on to that change and try to make something of it. So do you think, would you say that the change has perhaps reduced confusion and enhanced the clarity of Part 7?
I don't know. I suppose in a general sense, if you put yourself in the shoes of a self-represented litigant who's trying to navigate the system, as opposed to where we sit as family law specialists, there is a lot of words in Part 7 in all of these sections that are being, or that are proposed to be amended. So if you put yourself sort of in the shoes of a punter who's trying to make sense of it, if all they see is best interest of the child are the important bit, and then the convention, I suppose that's, in a general sense, easier to digest than trying to make sense of all of these other provisions. Because then the next step, I guess, is to think, okay, where do I find best interests? And you look at the table of contents in the Act, and you go to Section 60CC, which itself, of course, is being drastically amended if this bill passes Parliament. Yeah,
we'll have to see, won't we? It was proposed to greatly shorten Section 60CC, and that's been done. We started off, in the current legislation, we've got, I think, 15 factors, and it goes to 6, which is, I think the wording is pretty similar to what the Australian Law Reform Commission proposed. So the first question, I guess, is what's going and what will be left?
Yeah. And I think it helps to look at what it actually says at the moment. And in my view, Section 60CC as it currently stands is quite unwieldy. And as you said, there are 15 considerations plus the sort of catch-all provision, the catch-all consideration. So we've got the primary considerations, which in a sort of very glossed over sense are the benefit to the child of having a meaningful relationship with both parents, and the protection from harm. And of course, there's already a provision there that if there is a conflict between those two, the court has to give priority to protecting from harm. Those are the primary considerations. And then we've got all these additional considerations, many of which, in my view, sort of overlap and repeat each other. You've got any views expressed by the child, and then factors that influence the weight to be given to those views, the nature of the relationship with the child, of the child with each parent and other persons. So that captures other adults, significant adults in the child's life, and possibly siblings. The extent to which parents have taken or failed to undertake the opportunity to participate in decision-making, to spend time and to communicate. The extent to which parents have fulfilled or failed to fulfill parenting obligations, the parents' obligations to maintain the child. The likely effect of any changes to the child's circumstances, including likely effect on the child of separation from certain people. Practical difficulty and expense of spending time with the child, and this is one that I think we need to come back to in the discussion. So, yeah. The capacity of each parent and other adults to provide for the needs of the child, including emotional and intellectual needs, maturity, sex, lifestyle, and background of the child, and of either of the parents or other adults. Then there's a specific provision for Aboriginal and Torres Strait Islander children in relation to being able to enjoy their culture. And I note that remains in the amended version, or the proposed amended version. The attitude to the child and to responsibilities of parenthood demonstrated by the child's parents. Any family violence involving the child. if a family violence order applies or has applied to the child or a member of the child's family, the relevant inferences that can be drawn from the order, and there are a bunch of factors to be taken into account there. And again, I'll just pause there. So there's two additional consideration relating to family violence, in addition to the primary consideration of protecting from harm, which includes harm from violence, including family violence. So, and that's sort of where I think there's a fair bit of duplication and repetition.
But some would say that was emphasising the importance of family violence, and maybe family violence isn't as emphasised in these new provisions. And also, do you want to comment on that?
Well, it's an interesting point, because I've seen sort of in all anecdotal, of course, but in terms of the discussions I've seen amongst practitioners and platforms like LinkedIn, there have certainly been quite a few people who've expressed concern about it, because I think it puts too much extra emphasis on family violence in terms of views I don't necessarily agree with, but there's idea that people will make up allegations of family violence to try to advance their case, and concern that it places too much emphasis. I disagree with that.
Well, would have been a problem with the current legislation anyway.
Well, that's my view. It just rewords it, really. I don't think it really puts any greater or lesser emphasis on it.
Well, the other change about family violence is this provision of safety from family violence, with the introduction of a new hurdle, a new test. When we're talking about safety, do you think does that make an extra layer of difficulty?
I don't know. I don't think it will. But again, like so many of the changes that are proposed, it's really a matter of waiting to see how the court will interpret it.
Well, safety is not defined in the Act, which is pretty interesting, isn't it? We've got a new term, so who knows what will happen with that.
And just to cover off the last little bits of the existing Section 60cc, in sub L, we've got whether it would be preferable to make an order that would be least likely to lead to the institution of further proceedings in relation to the child.
Well, that's gone.
That's going, and then there's the catch-all. So that's sort of where it sits now. And as I said, I find a lot of overlap there. And what I often do if I'm doing a final submission in a trial on a parenting case is I sort of cluster them together, rather than addressing each of those factors, where really the submission on the protection from harm and family violence orders, really those are the same submissions. So what I tend to do is sort of group them into I think it's 5 broad categories. So I sort of do the child's relationships, which captures 60cc 2A, 3B, 3C, and 3D. Then the risk of harm, which is those 3 that I've spoken about, which is 2B, 3J, and 3K. The child's views, which is a standalone category in the existing legislation and in the proposed new legislation. I then group parental capacity, responsibility, and involvement into one sort of cluster, being subsections 3C, 3F, 3CA, and 3I. And then I address the orders least likely to lead to further proceedings in Section 60cc 3L, I think it is. But that's, as you said, that's one of the ones that's going to be gone in the new regime, if that comes in. And just I'll note also that I haven't addressed the Aboriginal and Torres Strait Islander children specific provisions, just because in my practice it hasn't come up very often. So it's not one of my sort of standard things that I address. But of course, as a case requires it.
Yeah,
that's
it's still going to be there.
Yeah.
But getting back to the family violence issue, family violence was, is a primary consideration along with best interests of the child. It was specifically referred to as a primary consideration, as well as, I guess, the duplication in the additional considerations. So I think there is an argument that it has been demoted, perhaps, in weight.
Maybe, but if you, I'm not sure how much weight anybody gives to the order in which the factors are listed in the bill, but the very first Section 60cc factor of the new factors is what arrangements would best promote the safety of the child and each care of the child. So arguably it's being put front and center in the new provision. How that leads to how it's interpreted is a different question.
Another change is the new Section 60cc 2B refers to any views expressed by the child. As you said, the previous the current version, I'm going to keep saying that, I'm sorry about that, is any views expressed by the child and any factors such as the child's maturity or level of understanding that the court thinks are relevant to the weight it should give to the child's views. So under the new or proposed bill, any views expressed by the child doesn't have all those other limitations. Do you think there's anything that we can make of that? Is it going to have any impact?
I don't know, but I think the overarching thing is, the Section 60cc factors are matters which the court must consider. So it's obligatory to consider the child views, and I suppose that's a slightly lesser hurdle than the views and the maturity and all those factors, because the views must be considered even if the child is immature.
Yeah, we might have some arguments about that.
Indeed, but ultimately, it's about determining the child's best interest, and if being forced to consider a particular factor doesn't equate to being forced to give it significant weight.
Sure. Yep. Sure.
So I suspect judges will still weigh up those matters. Will still look to family reports to tell us, is this a 9-year-old who's particularly mature, or a 13-year-old who's particularly immature, and therefore their views may or may not be given a great deal of weight.
And actually also, if you look at the UN Convention on the Rights of the Child, that refers to the maturity. That brings in the sort of the rest of the wording that is in our current legislation. So maybe there will be opportunities to refer to the UN Convention.
Yeah.
The other change I think is interesting is that in our current, at the end of the shopping list of factors in Section 60cc2, it's any other factor or circumstances that the court thinks is relevant. The proposed version is anything else that's relevant to the particular circumstances of the child. Johannes, do you think that's going to change the way this is interpreted?
I don't. I think, to me, it's again saying much the same thing in fewer words, because I suppose in some ways it might be sort of narrowing it to being things that affect the child, but ultimately it's all of these factors are a list of matters to be considered to determine a child's best interests. So it all sort of relates to the child anyway. And so if it's a practicability issue that affects a parent, it's all in the context of determining a child's best interest anyway. So I suspect it's not going to make a huge difference. What do you think?
I'm not sure. And I also wonder, how many clients actually read, or parties actually read the Act? I don't know if there's any research on how much they read the Act and whether or not it's actually going to make any difference. What parties actually understand by the current Section 60cc2 factors, and whether or not the change is actually necessary. It's nice to make legislation more accessible, but we don't know actually how often people read it.
But I suppose that there's a difference between parties in general who have lawyers versus self-represented litigants. And I get the distinct impression that part of the simplification is in recognition of the rising level of self-represented litigants we have in the courts.
Sure. And I missed out one other factor that's changed, that's the order least likely to lead to future proceedings is proposed to be out. What impact do you think that will have, Johannes?
No idea. It's I suppose tying in with some of the other amendments in terms of reinstituting proceedings, which, and again, we're going to talk about some of that a bit later in terms of the codification of rise and aspirant, whether that makes this particular consideration irrelevant or less relevant because we've got this codification in the Act of those concepts, I don't know. But it's but it all really relates to the finality of the orders, doesn't it?
Yes.
And as we so often tell clients, final parenting orders are never guaranteed to really be final.
Yep. And we'll get to the rise and aspirant a bit later. But I wonder if it will mean that if you think that you want the order to be the least likely to lead to future proceedings, whether or not you're going to look at the purpose of the Federal Circuit and Family Court. That might be where you have recourse to what the litigation purposes are. Do you know that?
In terms of keeping everything constrained, minimising costs.
Minimising costs, all that sort of thing. Maybe we have that broader principles will come into play. In the case management guidelines and those sorts of things. So isn't the government proposing to get rid of some of the more practical aspects of Section 60cc, and in particular things like the practical difficulties and costs in relation to children spending time with both parents? So do you think, Johannes, it might lead to some relitigation of the law relating to relocation cases? Because it strikes me that when you have a family report, often the practical considerations of children spending time with each parent aren't considered in as much detail as they might be in the course of a trial. So it might be that people perceive that the law on relocation has changed if this bill passes.
It's a very interesting point, Jackie. I suppose if you're arguing a relocation case in court, you would certainly address those practicability issues under the catch-all factor. I think there's still scope for the court to consider it. But then again, how the court deals with that, I don't know, because if you're opposing, if you're pushing for a relocation and the other side is arguing all of these costs factors or distance factors or whatever it may be, I suppose if you're the one pushing for the relocation, you might then argue, well, all of this case law that considers those things should go by the wayside because it's no longer a specific provision in the Act, and Parliament's intention must have been to put less emphasis on it at the very least.
I guess probably what we both would expect that there would be some, outburst of litigation at the beginning, and once this bill was implemented, and it may take a short time to settle down and be for people to be reassured that the law hasn't changed, or it may take a bit longer. Yeah,
and again, I think it's as you say, it might be an early burst of cases to get those answers, but I think it is one of those things we'll have to wait and see, because depending on where you sit in a particular case, you might as well try it on, I suppose. If you think you've got a new way, a new way to chart a course through that sometimes very difficult area in terms of relocations.
Section 61DA has been repealed, and surely this has to change things, because Section 61DA is the presumption of equal shared parental responsibility. Will we still use the term equal shared parental responsibility now that it's no longer in the Act, or we just use parental responsibility? And I think the ALRC suggested changing the term to decision-making responsibility, but that's not something that the government's adopted. I think decision-making responsibility would be much clearer for the punters, as you say. But what term do you think we'll be using?
Given our nature as family lawyers and our, I suppose, stick-to-itness in terms of the language we use, I suspect we'll continue using equal share parental responsibility for some time. I still hear people in court regularly referring to joint parental responsibility, which is a throwback to several amendments of the Act ago, I think. I suspect we'll be dealing with ESPR for some time, just out of habit, if nothing else.
Do you think that it's going to actually create, getting rid of the presumption, does that mean that it's actually going to be easier to get an order for sole parental responsibility?
I honestly don't think it'll make a huge amount of difference at all, because what you've got with the presumption at the moment is that we've already got a carve-out that it doesn't apply when there are reasonable grounds to believe that a parent or another person who lives with the parent has committed child abuse or family violence. And we've got the ability to rebut the presumption on the basis that it would not be in the child's best interest to have ESPR. And really what removing the presumption does is it puts the decision sort of at large on best interests as to how parental responsibility should be allocated between parents or other adults. So with the presumption, what we have is we've got this baseline of equal shared parental, and if somebody applies for anything other than that, it goes to a best interest test anyway, because the court has to consider whether the presumption is rebutted. So it puts a bit of an onus on the party who is seeking to do something different. So in my view, all that really changes is that when it comes to making a decision, the onus is equal between the parties rather than being on the person who's seeking something different. But I think in practice, most parties come to court seeking equal shared parental responsibility, and it's a non-issue in most cases. And I suspect that will continue. I don't think there'll be a flood of cases where suddenly it's like, oh, well, the presumption's gone. Now I'm going to try to make all the decisions about my child.
Yeah, I don't know. I think I must have different clients than you have. I think more of my clients are going to be seeing this as an opportunity where they might think it might be easier to get sole parental responsibility.
Perhaps, and I suppose we'll wait and see. But I suspect what the court will do is probably still find that in most cases it's in the child's best interest for parents to both be involved in those decisions, is my suspicion.
Yeah, so you don't think that's going to make much difference, that repeal, but surely you think that the repeal of Section 65DAA will make a difference. Under the current Section 65DAA1, if there's equal shared parental responsibility, then the court must consider whether equal time is in a child's best interest. So, and then, if it's not, then it's significant and substantial time, which again, that's gone. So what difference do you think that's going to make?
possibly controversially, I think it will make no difference at all.
Mm.
I've always found that section to be a little bit weird, because it's sort of telling a court, you must consider this no matter what, as long as there's an order for equal shared parental responsibility.
Mm.
Ultimately, all of those things, the time arrangements are going to be determined based on that paramountcy principle of best interests. And, you know, it's a weird situation that we have now, because we could have a matter where nobody's seeking an order for equal time, but the legislation obligates the court to give it consideration. And oftentimes that consideration is, well, neither party is seeking it, so clearly it's not going to be in a child's best interest or practicable to make that order. And then we move on to that second step of substantial and significant time, which has the same issue. If the reality is, in my view, if a party is seeking equal time, then the court is going to consider it, because the court has to consider that application and has to give that party procedural fairness in terms of hearing the submissions on it. If nobody's seeking it, why is the court being forced to consider it?
Yeah, but there's the other flip side of it, though, is by the repeal of this section, does that mean that the government is saying to parties and their legal practitioners and to the court that they don't see equal time or significant and substantial time as being sort of there's not the same emphasis on them, and maybe those orders won't be made as often?
Perhaps. And again, it might be a wait and see thing, but I think ultimately the court will apply the same tests to determine them. It may be different if if you're settling things outside of court, but I think the way judges will apply it, I expect will be much the same.
Well, I've got a view. I think that the abolition of this significant and substantial time might make it more difficult for legal practitioners negotiating outside of court and trying to get their clients to agree to an outside of court settlement, because it won't be the same benchmark. That it's easier for I guess a party to realise that maybe they're not going to get equal time, but significant and substantial time, if they're getting that, then they know that that's sort of a benchmark, and they can maybe agree to settle the case on that basis. And it also helps with the primary carer, that they know that there's a risk of significant and substantial time. Well, that's a significant risk that sort of order will be made. And so you can assist your client to get to that benchmark, if you like. And we'll lose that. We'll sort of be at large, if you like.
Yeah, but that may just be one of those things again where people wait and see what the court does with it. I suspect that it won't significantly impact the decisions the court makes. Of course, I don't have a crystal ball. I'm predicting things here, but I think the court will continue to apply best interest principles in their new form if this legislation is passed. And it may be that early on there's a difficulty with that, because again, people think it's a new frontier, new provisions, and we don't have to think about those sort of concepts of substantial and significant time anymore. But my expectation is that we'll have cases being decided by the court in much the same way, and then perhaps in 6 or 12 months after the new legislation comes in, a client comes to you and says, well, there's no, I don't want Dad to have this much time, and you'll say, well, all of the case law says that this is usually what happens in most of the cases.
But the cases won't be referring to significant and substantial time, will they? That concept.
No, but we'll probably still have a pattern of decisions where parents do get substantial and significant time because it's in the child's best interest. But again, it's one of the many things where there may be unintended consequences, and we really have to wait and see.
The Schedule 6 is the codification of Rice and Aspland. The intention of the addition of Section 65D AAA is to codify the rule in Rice and Aspland. Johannes, what's the rule in Rice and Aspland?
It's that general concept of final parenting orders should be final, except if there's a significant change in circumstances that's arisen since the final orders were made, or if there was some information that's become available that wasn't available to the court when the decision was made, or I suppose in the context of a consent order to the parties when the decision was made. And
so this new section does sort of codify it, and it does seem to largely reflect the rule in Rice and Aspland. And that was a recommendation of the Australian Law Reform Commission.
And to me, that looks again as the government attempting to make the law a bit more accessible, because of course, as family lawyers, we all know the so-called rule in Rice and Aspland, Of course, the courts keep telling us it's not a rule; it's just sort of a principle, but whatever we call it, we're all aware of it. If you're a self-represented litigant, it's not something you'd be readily aware of, I imagine, and this sort of puts it in black and white in the legislation, which I suppose is a useful thing. But do you have any concerns about it?
Well, my concern is a bit to the side, I guess, that since the decision of Oberlin and Infield, which was a 2021 court decision of the former family court, full court of the family court, I think it was often the case that we'd put notations in orders to try and protect parties from the rule in Rice and Aspland. And that's particularly the case when you've got young children, or you've got a party who's had a mental health or a drug or alcohol problem, and they've moved on from that. And the parties aren't, or maybe the primary carer is not really ready to implement or agree to orders which might carry the family through over a number of years. And if you put in the notation in the orders that the parties accept that the rule in Rice and Aspland doesn't apply, and that they'll be able to change the orders in say 3 years' time, because the children will be older, or the party who had the mental health or other problem will have, if they've maintained
track record
sort of thing. So I think that helps to resolve cases if you can reassure clients that with that notation that they can come back to court, because the Rice and Aspland rule is pretty tight. It's a pretty big hurdle to pass.
And what you're really talking about is that band of cases where you're expecting a change to occur, but it's a question of whether it meets a threshold of being a significant change. Yeah.
And what concerns me about the proposed amendments is that it doesn't address that. In Oberlin and Infeld, it said those notations are of no effect. So, how do you get your clients to sign up to orders particularly when you're negotiating outside of court? And maybe they might think that they're better off to run the risk, go to trial, because then they don't have to, they might get the orders they want. But they might last them longer.
But I suppose if the full court's told us that those notations have no effect now anyway, what's the difference? We're still putting them in. And I suppose on the basis that we might know that they're of no effect, but it might give clients peace of mind. What's the difference if it's in the Act versus in the...
Well, isn't it a missed opportunity for the government to address that issue?
And to allow carve out effectively.
To allow parties to settle cases and know that they've got the opportunity to go back to court when circumstances have changed, not necessarily meeting the Rice and Aspland test. If the Rice and Aspland test is in the legislation, that's really, as you say, makes it easier to access that law. So maybe even with self-represented litigants, it's going to be harder to get them to settle outside of court, because they'll see the wording of the Act and they may not have had access to the Rice and Aspland test.
Yeah. Your firm made a submission, didn't it, in terms of the draft exposure bill?
Yes, really.
Is this one of the issues you've addressed?
Yes, it is. Yeah, I think it's one of the concerns that we have, that it was a missed opportunity really to... because we do want to be trying to keep settle our cases and keep our clients from proceeding to trial, and I think that's one area where we're finding it more difficult at the moment, particularly with those younger children, and when you know that over time you might have a primary carer who's concerned about agreeing to significant and substantial time, or even equal time, but over the course of the child getting older, that they might be more amenable to it, and especially once the parents have the opportunity to see how the child copes, because the parents say, "Oh, look, I don't know how my child's going to cope." And it's not really about there being a significant change. It's really about the primary carer getting used to the arrangement often.
And sometimes also just the idea of we don't have a crystal ball. We don't know what's going to happen in the future. I ran a trial where that was an issue last year, where a family report writer had recommended this very long-term progression to equal time, I think over something like 10 years. And I was going to make some sort of argument about you can't predict the future and so forth. And the judge during the opening said, well, I don't have a crystal ball. How can I possibly consider that for I can't remember how old the child was, I think 4 or 5. How can you predict what that child is going to need in 10 years' time?
We tell our clients, don't we, that, a final parenting order isn't final. But we also have to tell our clients about the objectives of the court, which is to try to finalise matters as quickly as possible, get them out of court, and not have repeat offenders, I guess, in court. You're not coming back to court repetitively. Which I guess leads us to the new harmful proceedings order, that this is an addition to the vexatious proceedings power.
Yeah.
And the idea seems to be, well, that you can have an order that there's a harmful proceedings order to prevent proceedings from being brought by a party.
Can you explain what the difference is there in terms of between what does it mean to be a vexatious litigant and versus harmful litigation?
Well, my understanding is that the current vexatious proceedings powers focus on the intent of the applicant rather than the effect that further proceedings may have on the respondent. So we're looking at it from a different angle. We're looking at the effect on the respondent rather than the intent behind applying for making a further application.
So you could have an applicant who has all the best intentions in the world who could still be caught up by a harmful
absolutely. And the recommendation in the Australian Law Reform Commission report referred to the case of Marsden and Winch, a 2013 decision, and it was they used that as an example of the gap in the court's powers to scrutinise the institution of further proceedings. That case involved protracted and persistent litigation over many years. It didn't meet the vexatious proceedings test, but the judge found these proceedings substantially led to the other developing post-traumatic stress disorder. And the Australian Law Reform Commission concluded that the existing vexatious proceedings provisions and summary dismissal powers don't provide sufficient scope for courts to make appropriate orders in cases where one party oppresses the other by repetitive filing of applications and the serving of those applications on the other party.
Yeah, it sounds to me a little bit akin to the Reandrew principle.
What's the Reandrew principle?
So I find a really nice summary of it in a case called Blinko and Blinko, which is a full court decision from 2015. The medium neutral citation is 2015 Family Court of Australia full court at 146. And in paragraph 83 of that decision, the full court sort of summarised the state of the law of what's the so-called Reandrew principle from the cases that have been decided since then, with particular reference to a case called Russell and Close from 1993. And the concepts are, and sorry for looking down, but I'm going to read it. If a court is satisfied that a parent represents an unacceptable risk of harm to a child, then unless that risk is able to be sufficiently managed or ameliorated by, for example, supervision of time or communication between parent and child, the best interest of the child may require an order prohibiting the parent from spending time and communicating with the child. So that's sort of the basic unacceptable harm sort of test. And the Reandrew principle comes in at the next point. If the court does not find that the parent represents such an unacceptable risk of harm, nonetheless, it may take into account anxiety on the part of the other parent arising from their genuine, but not necessarily rational, belief that the parent represents such a risk of harm. So in other words, the parent may not actually present harm, but the other parent may have such anxiety about their perception of the harm. And then it goes on, in such a case, the other parent's belief must be genuinely held. If it is entirely irrational and baseless, then the genuineness of the belief would clearly be open to doubt. However, where such a belief is genuinely held, if the child spending time with the parent would sufficiently erode the other parent's capacity to properly care for a child, then that may of itself mean that the ensuing detriment to the child determines that it's in their best interest not to spend time. And then the last point is further, where there's a history of abuse, violence, or like behavior between the two parents. Where the history of abuse, violence, or behavior between parents means that continued interaction between them would similarly erode the resident parent's capacity to care for the child. The need for peace and tranquility in the household may be a more compelling need for the child, and hence also might justify an order prohibiting the other parent from spending time communicating with the child.
It's interesting, isn't it? I mean, is there a floodgates argument here that by allowing harmful proceedings orders to be made, so to prevent a genuine litigant from bringing an application merely because of the effect on the respondent or the possible effect on the respondent compared to a vexatious litigation order, which, is pretty hard to get. I mean, have you ever had one?
I've not had one.
No.
I've also never applied for one, I must say. So
yeah, I mean, they're pretty rare. So I mean, maybe there is some room for it, but I think there's surely some concern that maybe these sorts of orders might be sought too readily? Do you think? Because the test.
Well, it might be that people try it on as a tactic, I suppose, to get rid of proceedings on a summary basis, effectively. I'm not sure it'll be determined summarily,
No.
or with some sort of hearing, but it's again, it might be one of those things that people try on, particularly early on, when we don't know what the court does with it.
And how does best interest play into this harmful proceedings test?
Well, this is where I sort of thought there might be a link to the Re-Andrew concept, because that's, of course, a best interest test ultimately, because the idea is even if the non-resident parent doesn't actually currently pose a risk of harm, the other parent perceives it. And that might be in a case where, for example, there might have been protracted family violence or drug use or any sort of those things where there was an actual risk of harm previously. And that may have been what led to the separation, for example. And then, you know, I think you spoke earlier about, you know, a person coming good and having that track record.
Yep.
And it could be that, you know, they now apply to the court when they've got a bit of a track record of being off drugs or having done their anger management courses or whatever it may be, then applying to the court for time with their kids when they perhaps haven't had any, but the other parent and perhaps even the children being quite traumatized from the historical abuse or the historical issues, that then there's that risk. And so I suppose that's where, again, it's that best interest test of, you know, is the child better off having a functional primary parent, and is that more important than the relationship with the other parent? And what Re-Andrew says is in cases where that anxiety is high and generally held, that can trump the relationship. And I suppose it might be a similar sort of a question and a balancing that the court has to do.
Sure. But it might mean that there will be some more litigation. Well, I think undoubtedly there'll be some litigation on this as to what circumstances someone can get that order. Because if you're looking at the impact on the respondent, I mean, okay, the case that the LRC referred to, the mother developed post-traumatic stress disorder. I mean, that's pretty significant psychiatric diagnosis. There might be other cases which don't have quite the same severe diagnosis, but maybe there's an opening for those sorts of harmful proceedings orders to be made. And I can think of a number of cases that are clients of mine on both sides where, you know, one of them might want to apply for this type of order.
And I suppose the difference between this sort of provision and the Re-Andrew type concept is, of course, the Re-Andrew argument is one you make at trial. At the end of the case, it doesn't actually stop the proceeding.
Yes.
The party who might be harmfully impacted by the litigation will at the moment still has to go through it and might then succeed on the Re-Andrew argument at trial to stop time proceeding. But that might happen after 2 or 3 years of interlocutory hearings and reports and all that sort of thing. Whereas I suppose if you've got a client who has that sort of a case to run, that might be where you then can make this application and short circuit the process.
We probably should move on to talk about a restriction on publication and protecting confidences. And this is, well, first of all, the draft bill introduces a new section 99 on the admissibility of protected confidences. This is protecting medical notes, but you can apply for leave for them to be admitted. And the court, you know, has to consider whether to grant leave to admit evidence in proceedings, and looking at the public interest in admitting the evidence outweighing the public interest in preventing harm to the protected confider or the relationship the confider has with the treater. So do you think that's going to change what happens when subpoenas are issued against these?
Well, what isn't clear to me, and you may have read it more closely than I have, but is whether where this sort of prohibition will apply. Will it be at the stage of seeking to issue a subpoena? I suspect not, because we're not in the old family court days where you had to have leave to issue a subpoena. You've got you've got your 5 that you're allowed to seek. So I suspect not at that point. But what's unclear to me is it going to be you issue your subpoena for my client's medical records, I file an objection on the basis of this provision, we have a subpoena objection hearing, and that's the point where the decision maker then says, no, you need leave to get this? Or is it going to be, yep, you can get those records out, but it's going to be a question of leave to actually adduce it at a trial or at an interlocutory hearing? And you know, to me, it has a sort of a sniff to it of this issue of relevance in terms of what the Evidence Act says is relevant for admission of evidence versus the relevance test when you issue a subpoena in terms of having documents released.
You know, I wonder whether it's going to change the way subpoena hearings run. You know, like, is it going to mean that you have to, because there are a number of factors listed in section 99(7), such as the probative value of the evidence, the importance of the evidence, the availability of other evidence, like public interest, those sorts of things. Yeah. But does that mean that you get access to the subpoena documents before you run your argument, or do you have to run your argument before you can actually see the documents and then determine whether they're admissible?
Well, normally you have to run the argument on a subpoena objection hearing without seeing the documents, and that relevance test I was referring to. What I often cite is that oft-cited judgment of Justice Cronin in Anderson, and I haven't got the reference in front of me, but where he cites Portal Software, which is a New South Wales Supreme Court case, and there's this concept of it's sufficient that documents could possibly throw light on issues in the substantive proceedings, or that it appears to be quote unquote on the cards that they will do so.
On the cards,
it's on the cards, and that's of course a very different test to is it actually relevant to this proceedings, and I think that lower threshold means that it's easier to get access to the documents, and then when you've got them, then you can work out, is this actually relevant or not? And there's a difference between that and phishing, of course, because you know, you've got documents, you've got a class of documents that may be relevant. It's not purely trying to come up with a case. You've got a case and you want documents that may be relevant to it. And so I wonder whether it'll be a similar sort of concept here, where you know, the question of leave may be left to the trial, or at least may be determined on a lower threshold, in terms of it may be that a similar sort of argument might be run that, well, we don't know yet whether the probative value and the competing interests, how they weigh up without seeing the documents. And maybe that you persuaded a judicial registrar or a judge who's hearing the subpoena objections to let you look at them, but it doesn't follow from being allowed to look at them that you can adduce them. But I mean, who knows?
Who knows? I mean, the purpose of the legislation seems to be that, you know, there are instances where the ongoing relationship between a party and a therapeutic provider could be negatively impacted by the production of the evidence. And also, you know, we all know that some people use the demands for medical notes, those sorts of things, as sort of family violence, controlling behaviour, I think systems abuse. You know, that this is the harm that's trying to be addressed. But you know, there are obviously instances where such evidence is of significant probative value, is directly relevant to the matters in dispute, to the best interest of the child. But sometimes you don't know until you see the evidence.
and maybe again that where those arguments and at which stage those arguments come up depends on the case. If it is a case where there's been coercive control and someone's issuing a subpoena to these documents, and it looks like it might be part of a pattern of abuse, that might be then an issue that's raised as part of the objection process. And in a case where there is that history, the court may be less likely to release the documents for inspection than if there hasn't been that history. That might just play into it.
So you're saying that maybe the law has changed? Because I mean, on the face of it, I wonder whether the law has changed at all. But if you think that maybe...
Well, I suppose at the moment, if you subpoena someone's medical records, isn't it always possible that they may throw some light on an issue in a parenting case, in terms of relevance? I think the relevance you probably could get across pretty easily. But if there's now a provision that seeks to protect that confidential information and it's an extra hurdle, I think that is a change.
Right. Okay. I think medical evidence is in a separate category now. You know, that it's not released willy-nilly.
Copying and released to parties versus lawyers.
And access by, you know, the party whose medical notes they are might happen first, so that they can know whether they want to raise an objection. So I think they are treated a bit differently now. I'm not sure that it's actually going to change the law, but maybe you're right.
I think at the very least it'll be a slightly higher threshold to get access.
The other part of this is the protected section 121, which is the publication provision, the protection of family court proceedings from being published. What's proposed is a new part 14B, and what we need is another part to the Act, don't we? And so section 121 would be completely gone, redrafted. The Australian Law Reform Commission proposed that the family section 121 be redrafted to make the obligations imposed easier to understand. I think we've probably got no.
I think that's fair, isn't it?
Fair result.
What does it mean to publish to a section of the public?
Yep. They also recommended that to clarify that governments, agencies, family law services, service providers for children and family violence providers are not part of the public. That doesn't seem to be expressly in the new provision. But the previous government, in its response to the ALSC report, said that they wanted to strike a balance between the competing principles of open justice and the rights of children and families to privacy. And I think we'd all say that's pretty fair enough too. And the intent is to try to protect the privacy of families and children from intrusive media reporting. But there was also problems about what does publish mean, and also with the onslaught of the internet, social media.
Particularly social media. It's publishing if you're posting it in a private WhatsApp group or a Facebook Messenger chat or something like that.
Well, I think that's addressed. That sort of is by the new part. But what do you think communicate means? I don't think there's a definition of it.
It's a fairly inclusive definition, isn't it?
It says communicate by any means, but it doesn't actually say what communicate means as opposed to what publish means. But is it broader, do you think? I
think it must be than publish, because communicate, I mean, if I send you a text message with some information in it, have I published it? I think probably not.
No.
It's not a public communication, it's a private communication. And I think that's the big difference. I can't tell you exactly what it means to publish in the context of section 121, but I don't think it includes a private communication.
Well, private communications are actually specifically excluded in the new one.
So what's that exclusion?
Section 114S. Some examples of the exclusion are private communication to friends and family. So we've got a specific exclusion carve out in the new part, which didn't exist before.
So that could be, for example, where you tell your new partner about what's been happening at court.
Yeah, which you do anyway. Yeah. So well, it wasn't an offence really.
Yeah.
There's also another broader exception, I think, which is section 114S1, where a communication is not made to the public if the communication is made to a person with a significant and legitimate interest in the subject matter of the communication that is greater than the interest of members of the public generally. Not sure what that means. What do you think, Johannes?
It seems pretty broad.
It seems pretty broad, yeah.
I would have thought anyone who's got an interest in the child's welfare would fall under that definition. So teachers, principals, doctors, childcare workers.
Well, they're probably within
sports
the old
coach.
Well, I think they're probably within the old section 121 carve out, because you could publish to members of the a profession, which was pretty general, could include school teachers, that sort of thing. So what will we be doing, do you think, under the new Act? Do you think we'll be getting injunctions more commonly to prohibit communications?
Well, if the carve-outs are bigger, perhaps, because I think currently, I don't know, I often, out of an abundance of caution, just seek an order to be allowed to provide things to certain people.
Sure, yeah.
Particularly with the more protected documents like family report and so forth, where you want to be able to provide a family report to a treating psychologist, for example, for either a party or a child. And I suppose if we've got broader carve-outs here, you might want to then restrict it and pare it back to who can get it.
Yep.
If there might be a document where your client might say, well, I actually don't want the school principal to see this because they shouldn't have all this private information. And if the carve-out is broader and allows the school principal to have it.
And there might be one party who really doesn't want the school principal to see it.
And that even, I can think of a case that I was involved in many years ago where the court made a suite of interlocutory parenting orders, and it was important that some of those orders were given to the school in terms of what the time arrangements were, and we had that provision in it that says the orders can be provided to the school, but the judge in that case specifically decided to make two separate orders at the same time.
Right. Yes.
One set of orders which was all the stuff that was relevant to the school, and then the other stuff which addressed things like the drug testing and the injunctions on drug use, where the judge said, well, there's no reason for the school to be aware that these are issues or that these allegations exist in this case at this point. What the school needs to know is what are the time arrangements, who's going to pick the children up. And so, you've got those sort of things where the court already wants to limit it. So I suspect putting in limitations and injunctions on those sort of points might not be a very difficult get from the court.
Well, I like the idea of two sets of orders, actually. I think probably we should be doing it more often.
Well, and you might even, it's not strictly on topic for today,
No.
but it's a sort of thing, often we do final parenting and property orders in 1 minute.
Yep.
Does the school, which might need the
Yep.
parenting provisions, need to know how the property is being divided? Probably not.
And also, the parties are going to be referring to the parenting orders presumably on a more frequent basis. They don't need the property orders to be...
Which are implemented pretty quickly usually.
Yes, yeah. That's right. They're done and dusted. We probably should move on and sort of summarise what the effect of all this is. I realised, Johannes, that I forgot to mention one change in the Section 60cc factors. So I think it's my fault there. I forgot to bring it up, which was the removal of the reference to grandparents. And I'm sure you remember, as do I, the big fuss around this implementation of that provision back in 2006, that there was a lot of pressure from community groups to expressly refer to grandparents in the legislation. And if the draft bill was passed in its current form, that will be gone.
There's no express reference to grandparents in the new Section 60cc as it's proposed. Grandparents would be captured in the other people significant to the child. And each proposed carer sort of provisions. What the section doesn't touch is Section 65, sorry, not the section, what the bill doesn't touch is Section 65 capital C, which talks about standing to bring proceedings.
Right.
And that there's a subsection there, which is a later insertion, for grandparents specifically to have standing. So grandparents don't have to fall into that general another person interested in the welfare of the child provision. They have their own specific express provision for standing. So I think grandparents still have the standing to start proceedings or to intervene in proceedings. So I think they will be captured, but again, it's one of those things where perhaps there's a bit of a demotion because they just now fall under other proposed carer or another adult who's involved.
Well, I imagine that the government will receive some major submissions on that. And some pressure on that to keep grandparents in, because I think, although they're still in, it's a different part of the Act, and I think that there's going to be some unhappy community groups, I think, about that removal. We should probably move on to sum up. Where do you see the main changes here, or lack of changes?
Well, I think the thing that people probably will focus most on is these changes to Section 60B, 60cc, and the removal of the presumption of the mandatory considerations. My overall view of that is more or less it's going to be the same effect as the current legislation. A lot fewer words, much simpler. And I think people may be up in arms about that and think that significant things have been cut. But my gut feeling is that it's going to be more of the same, but just in a way that might be a bit easier to read for non-lawyers.
Well, I agree that it's going to be easier to read. My concern, I think, is there are going to be some unintended consequences. I think we will see it just on the coalface. It's more difficult to negotiate final parenting arrangements because of this removal of the substantial and significant time. I'm not so concerned about the removal of equal time. I think that will help reduce litigation and help settle cases because it's gone. But I think that substantial and significant time was a bit of a benchmark that we're going to miss when we're negotiating. I think there's also, I'm concerned about the change for relocation cases, or whether people are going to see that the removal of the practicality sort of aspect of which is something that's not always addressed in family reports, quite often can't be addressed in family reports. And so removing that from Section 60cc, I think, will change things. And you can disagree with me about that. That's fine.
And I want to be clear, when I say that, more or less the same in effect, I suppose I'm talking more about in the way a court will decide it. I think the impact on out-of-court discussions and mediations and direct negotiations. I mean, as a barrister, the vast majority of cases don't come to a barrister because the solicitors settle them, and that part of it may be more impacted. I think I'm talking more about in terms of how the court will decide it, and what I expect is, and I think I said it earlier, is that in due course, as case law develops under the new provisions, if they're enacted, then that will guide all of us in terms of how we advise clients and so forth, and will then impact those negotiations. But absolutely, no doubt be unintended consequences. There always are.
There always are.
And then further amendments and
Further
further
amendments.
reviews.
And I think the harmful proceedings provision, I mean, that's new. That's totally new.
That's going to be very interesting
Yep.
to see how that develops.
So I guess the final message is watch the space. You know, it's all going to be new. Things might be tossed up in the air for a little while, but they'll settle down.
And then eventually the full court, sorry, not the full court, the appellate division of Division 1 will tell us what it all means.
Well, thanks for that, Johannes. I've really enjoyed talking to you today.
Thank you. Same to you.
And hopefully it's been helpful to the listeners to get a handle on what we're expecting.
Or at least know which bits we're completely uncertain about. Thank you.
Thanks.